It's wonderful to welcome Professor David E. Bernstein of George Mason University to this show once again. Last time we spoke, we discussed his latest book, Classified: The Untold History of Racial Classification in America. And today, I hope to discuss a piece that he brought to my attention. It is a chapter in the Cambridge Handbook of Classical Liberal Thought and is titled The Boundaries of Anti-Discrimination Laws. David, welcome to the show. How do you do?
I'm good, thanks.
Okay, so this chapter of yours was brought to my attention when you read something that I wrote, which is my reflections on a book titled The End of Racism, authored by Dinesh D'Souza. So I wonder first, what were your thoughts on that book?
I read that book a long time ago, but I thought you had a very interesting essay on it at the time. And I think one of the things that brought the book to your attention and thus to my attention is that D'Souza sort of broke with the consensus in sort of mainstream circles. And at the time, D'Souza's kind of gone a little bit off the deep end since then. But at the time, he was very much a mainstream conservative commentator, and he argued that progress in racial relations in the United States might depend on actually limiting or even eliminating laws that prohibit discrimination based on private parties. And at the time, this was like the early 90s, that was kind of a sacrosanct thing that everyone sort of accepted the idea that the government had a major role to play in combating discrimination.
Mhm. Yes. I remember the review that I wrote for that book was quite critical. I didn't think that um, many of his insights hold up, and also that he used um, uh, he used a quite inflammatory language to to describe or to make his case. And I know that it was a very controversial book upon its release, but I'm very surprised today that not many people remember it.
Yeah, the I think the book got a splash of attention, but I don't think it had much of a long-term influence on the debate. I think the book was somewhat inflammatory. You know, I think approaching the history of civil rights in the United States and not really taking into account the extent to which American history has been replete with really institutionalized racism, not just sort of, you know, relatively minor things like you may see becoming huge controversies today. But look, we had hundreds of years of slavery, Jim Crow, and Jim Crow. When you learn about Jim Crow in school in the United States, at least when I learned about it, you mean, oh, there was segregation, but it really wasn't just about segregation. It was a whole social system meant to really preserve white supremacy in the South. And I don't think D'Souza really approached the subject with sufficient empathy for that background.
Of course, this year, 2024, celebrates the 60th anniversary of the passing of the 1964 Civil Rights Act. So, as a law professor, why don't you explain to us the significance of the passing of that law?
Sure. So the 1964 Civil Rights Act was really a major achievement, or just whatever you think of it, was a major step in American history. For some reason, in law and even more generally, we tend to think of the Supreme Court decision in Brown versus Board of Education in 1954, which held that segregated schools were unconstitutional, as being sort of the main or major step in the civil rights movement. And certainly Brown had significance. It was a 9-0 opinion. It was the Supreme Court, obviously a very important body speaking on the issue, but courts in the United States don't have a lot of power inherently beyond just say, here's what we think the law is. And even almost a decade after uh, Brown was decided, the vast majority of public schools in the South were still segregated. Interracial marriage was still illegal in a good part of the United States, especially in the South. Um, and all sorts of other sort of civil rights issues really hadn't been addressed. The 1964 Civil Rights Act was a federal law passed by a majority of Congress, of course, but a majority of each party. It was basically everyone voted for it, pretty much except for people in the South, with a few conservative exceptions elsewhere in the country. And it really transformed the United States by putting the weight of the federal government behind the civil rights movement, behind a movement to treat people equally based on race. So first of all, it outlawed segregations. That was a big deal. But it also outlawed discrimination in employment, and it outlawed discrimination in federally funded education, which is basically all education, as it turns out. Because one thing that was going on at the same time is that Congress was able to leverage civil rights laws by saying, well, if you get government money, you have to do X and Y. And they started giving out a lot more government money. So it became almost impossible for governments not to accept the money and be subject to federal regulation. And it also uh, conditioned so it can so basically conditioned this federal funding for education on government on desegregation, which was really important. The one thing it didn't do that was really important was preserve the right to vote, which had been denied to Black people in the South for quite a long time. But that was done the following year in 1965 in the Voting Rights Act. So between the 64 Civil Rights Act and the 65 Voting Rights Act, it really was a transformation of the United States from allow at least the country, we are a federalist system, so a lot of the greatest oppression was in the South, but from allowing the South to have an official white supremacist agenda with segregation and lack of voting rights, and discrimination and overt discrimination employment, to a system where the United States government was an ally, in fact, the leading power in overturning the white supremacy system.
Mhm. Yes. So last year I read that wonderful book, The Strange Career of Jim Crow by C. Van Woodward, which really broadened my understanding of how that legal slash social regime came to be and how it met its end. And so you've, as you've alluded earlier, Jim Crow is both a legal and a social construct. So I wonder, during that time, did the legal part of Jim Crow follow the social or vice versa?
So this is a very complicated question, and I think that historians have been debating this ever since. Woodward's thesis was a sort of a relatively optimistic one, and the book was written right during the height of the civil rights movement. He basically argued that segregation and the Jim Crow system in general was not particularly rigid and was very vulnerable to social action and to just sort of evolution. And then the government came in and sort of reified it, made it part of the law. And the idea was that if the government then undoes the law, that could also undo the Jim Crow system. The way I tend to look at it is that you have three major aspects of the Jim Crow system. One was the formal law requiring segregation, or prohibiting Black people from voting and that sort of thing. The second aspect is just social pressure that um, the white community in the South would had a custom of treating Black people as inferior because of slavery, and that was sort of reinforced via social sanction. Like, you wouldn't invite a Black family to your house socially, or your neighbors will all get very upset, and people church wouldn't talk to you. But the third, which gets the least amount of attention, is it was also backed up by implicit and explicit state violence. When I say explicit state violence, I mean that if you went and tried to vote and you were Black, you might get beaten up by the police, right? That's explicit state violence. Explicit state violence was also, there was social control. If you were a Black male in certain parts of the South and were not employed, you would get charged with a misdemeanor crime of some sort, real or imagined, and then you'd be sent to work on a prison farm or even hired out to southern employers to make sure that you're kept under social control. The implicit form of the violence was that, first of all, of course, because there was explicit violence that kept people sort of in line, so to speak. But the other part of it was that if you were a white person and you were inclined to challenge Jim Crow for either economic or moral reasons, like economic reasons, hey, there are black employees out there that I could hire for jobs who are not able to get these jobs. Otherwise, I could pay them a little bit less. So it would be good for my profits. If you tried to do that, you would potentially face violence either from government officials or more likely from your fellow whites who would then not be punished by the state. So, for example, there's how much of Jim Crow is voluntary? There's a whole article saying, well, the cotton mills in the South were segregated. Blacks always had the worst jobs. There was no government laws requiring segregation. And this isn't my particular area of expertise, but in my historical research on the period since I've done it, I found a few examples of where employers who try to have a more favorable situation for black employees in their cotton mills were burnt down or they were intimidated into not doing it. So basically, the way I come to see it is that it's something approaching a cartel system, that you have a combination of the plotting among whites themselves, the explicit law to enforce the cartel, the implicit violence to enforce the cartel. And I think for a lot of this, you really needed all three legs of the stool, because otherwise there's so many incentives on the part of so many people to undermine it. I mean, it's really hard to get all white people together to agree to oppress black people. It's really hard to stop people from voting when they really want to vote. It's really hard to stop employers from or business people from trying to undermine their competitors who engage in segregation by treating black people better. If you have all three of these things together, it becomes much easier.
Okay. So back to the D'Souza's book. I believe uh, he relies on much of his case for um, the outlawing of, I guess, anti-discrimination laws in private practice on a book published a few years earlier by Richard Epstein, the libertarian legal scholar. Is titled "Forbidden Grounds," and that's where he makes that case first. So either you've read Epstein's book as well. So how do you characterize their case to to get government out of anti-discrimination laws in the private sphere?
Well, look, I don't know, I know Richard very well. I actually attended a seminar on that book when it wasn't even quite published yet, and we discussed it. And I've talked to him about this. And one thing that I'm not sure if he said this publicly or just to me, but he does agree that in 1964, if the choice was just to leave things alone or to have government intervention to break this sort of cartel that I'm talking about, that it was a better policy, even from a libertarian point of view, to break the cartel, because he's a very well-known libertarian. Now, I think one point he makes, and I don't recall if D'Souza makes it or not as well, is that it's really hard to implement. I mean, I think the most persuasive point about employment discrimination in particular is that it's really hard to implement an effective anti-discrimination program for the following reason. You're an employer, and as an employer, you have two equally qualified people. One's black and one's white. Now, uh, you expect to pay them exactly the same and expect them to have the same productivity. However, you also recognize that no matter what happens, uh, in the future with each employee, the white employee is very unlikely to sue you for employment discrimination. You're white, he's white, the odds that you're discriminating is really bad. When it comes to the black employee, if you hire the black employee, there is some chance, whatever it might be, that he will sue you and that will add costs. And in fact, one thing we've learned since the 64 Civil Rights Act came into being is that people are much more likely to sue for either not getting a raise or more likely for being terminated than they are to sue for not getting the job to begin with. Because there's a lot more damages available, and most people don't want to bother, even if they think they've been discriminated against in hiring. How do they have any proof? And they probably get another job the following week or month, so why bother? So, in other words, if you're choosing between these two employees, you have two employees who are exactly equal, except one of them is an extra cost because he might sue you, and the other one's not. So, in a weird way, protecting a group through civil rights law makes them more expensive. It makes you less likely to hire them. So, the law itself undermines the purpose. And this is a point that's explicitly not appreciated by anyone, but is implicitly appreciated by the whole system in the sense that, so how does the government wind up enforcing civil rights law? It does so statistically. It's if you want to sue for not being hired or for being fired, you sue based on well, there's this many employees, people, potential employees of this race in the area, or this many people you employed, and you uh, didn't meet what the expected percentage you would have in the population. That's what the federal government's referred to as goals and timetables. Now, goals and timetables made a certain amount of sense in 1964 because if you're an employer who's never hired any black people before and suddenly you're obligated to, a black person will say, well, they're obligated to, but they're just hiring me as a token and I'm not going to be well treated. Why should I? So, but here, no, we have, no, we have a whole program in place. But what it also means is that this also overcomes the problem that civil rights laws have, which is on the one hand, it's more expensive to hire the black employee because he might sue you. On the other hand, and by the way, sue might even be justified. Maybe you have someone who works for you who's going to mistreat them that you don't know about. So it's not even necessarily it's a fraudulent suit. It's just you're worried about getting sued. So if you have the requirement of meeting the goal or timetable, that on the other hand now makes it, on the one hand it's costly to hire the person. Now it's also costly not to hire them. So it overcomes that. So in other words, in a sense, once you have federal anti-discrimination law, once you have big employers being monitored by the federal government by having to uh, tell you how many people they've hired of which group every year. Basically, there's no such thing as federal anti-discrimination law without implicit affirmative action and goals and timetables, which sort of amounts to quotas. So I think I mean, there are other things in the book and both D'Souza and FCC as well, but I think one of the arguments I find if I was on that, taking that side of the debate, the strongest is that if you say you're in favor of employment discrimination laws, you are implicitly also inevitably saying you're in favor of affirmative action goals, timetables, ultimately something like quotas, which most people are against. Even if most people say, yes, I'm for anti-discrimination laws, but I'm against anything like quotas, but they go hand in hand.
Mhm. Okay. So that brings us to the role of the agency known as the Equal Employment Opportunity Commission, EEOC. I believe either during the passing of the Civil Rights Act of 64 or sometime after, um, discrimination on the basis of sex is also become part of the legislation. That is, it is against the law to do so. So, tell me about the role of that agency, the EEOC, and perhaps how it has evolved over time.
So, ironically, maybe one of the concerns that was expressed by people who were moderately in favor of civil rights law in the 60s, before the act was passed in the early 60s, was that, well, we want employment discrimination law, but we don't want there to be quotas. We don't want it to be that employers feel they have to hit a set number of employees. And we also don't want employers, being hit with lawsuits that aren't really justified. We have a unique system in the United States where lawyers get paid based on a percentage of the money that they recover for their client, and the client doesn't have to pay anything, and you don't pay the other side's attorney's fees if you lose. So there's always a fear for any kind of law in the United States that if you make it financially too attractive to sue, that there'll be more lawsuits than there should be because it's relatively costless to sue, and there could be big gains for the lawyer to encourage lawsuits. So the way they try to alleviate this concern was to say you can't just go and sue anybody you want under this act. You first have to file a complaint with the EEOC, the Equal Employment Opportunity Commission. The EEOC will investigate your complaint, and only if they find that it's justified can the lawsuit go forward. And that could have worked, except that the people who ran the EEOC back in the 60s were extremely aggressive in their policies. And instead of focusing on these individual employment lawsuits that they had to find justified, they went ahead and with the cooperation of the Justice Department, they started, again, creating these goals and timetables for employers and suing if they weren't met. And then I should add in 1970, in the Griggs Power case, the Supreme Court allowed, by a 9-0 opinion, allowed litigation to go forward solely based on statistical disparities. I think in that particular case, there were strong evidence that you need statistical disparities to show discrimination. It was in a particular canning factory, and members of minority groups always had the worst jobs. But nevertheless, the court, so they say hard cases make bad law. Sometimes easy cases make bad law because it's, oh, well, this is obviously a good case, so let them just sue based on statistical disparity. So between those two policies, again, this became, while the law was really was intended structured so that it would allow for individualized lawsuits in particular circumstances, or allow the EEOC to come step in if someone's out there saying no black people will be employed by my company. You can't do that. Instead, it became the subject of these large class action or bureaucratic action cases, like, hey, you're not meeting, you have a disparity this in the number of people you have relative to your local labor market, and we're going to sue you on that basis in a class action often, which was, or on behalf, if the EOC is acting, on behalf of all employers, which again put pressure on employers to have these sort of goals and to meet these goals and timetables and essentially resort to quotas.
Yeah. So, following up on your answer, so to what extent are affirmative action initiatives part of the anti-discrimination legal framework?
So there's no legal requirement in the United States that you engage in affirmative action, either in education or in employment. But it's in education, it's been ubiquitous, and in employment, it's been, if not ubiquitous, it's quite common. And at one time, this in employment in particular was driven by these federal rules that we just discussed. Over a longer period of time, it's become part of the corporate culture that we have to have diversity. Diversity is a priority, and thus we need to be um, not just actively looking for employees from different groups, but perhaps giving them some preferences to make sure that we are diverse. And I should say that I know not everyone is American who listens to your podcast. The United States, we have, our last discussion was about my book Classified, about racial classifications in the United States. When we say minorities in the United States, it's not necessarily who an outsider would necessarily think, oh, they're the minorities. It's basically people of African descent, whether they're recent immigrants or their families have been in the country since slavery times. It's people who have Spanish-speaking ancestry or even just ancestry from a Spanish-speaking country, which is sort of an entirely arbitrary classification. It was really meant to apply to people who look mostly like they're of indigenous background, who are brown, but it applies to anyone who has Spanish speaking background, and Asian Americans who are anyone is basically most of the world, anyone from whose family comes from India all the way to the Philippines and all everything in between. And in that context, Asians are subject to all the same protect. I mean, everyone gets, even white people are protected from discrimination in the United States. When it comes to sort of affirmative action, there was a time when affirmative action may have applied, at least in some parts of the country, to Asian Americans as well. But Asian Americans on almost every Asian American group subgroup is now more economically successful in terms of median family income than white people are. So in universities, if anything, affirmative action tends to disfavor Asian Americans because again, diversity is the buzzword, and we have too many Asians. Universities will say, and in employment, there might still be like in law, there aren't that many Asian Americans. So sometimes law firms, when they're looking for minority associates, will say, we'll include Asians. But for example, at tech firms, at leading tech firms like Google or Microsoft, 30-40% of the employees will be Asian American. So you'll often see this really weird dynamic where the New York Times will have a story about lack of minorities at big tech firms. They'll say that the firm is 90% white or 95% white. And then you go and you look later in the article in like paragraph 35, they mentioned that 30-40% are Asian Americans. Like, well, wait a second, that's not well, they're not white. So how are we just ignoring them entirely? So anyway, that's where we stand basically with this stuff.
I see. Yeah. So to revisit your classified book, it is true that the the classification of race in American politics and legal scene, it's questionable. Like there are a lot of questions to be posed with that. For example, when you refer to Hispanic Americans, so Americans who are originated from Spanish-speaking countries, I'm thinking of Latin American countries. Well, in those countries, there are those who are descended from the Spanish settlers back in the, I guess, 15th, 16th century, and there are also indigenous people, and those groups, in terms of economic advantages or economic performance, the descendants of Spanish uh, settlers, they tend to do better than the indigenous. And the same goes with the very broad category of Asian. There are some people who can trace their lineage back to certain countries like China or Japan, do much better than those who can trace their lineage back to either Hmong or Filipino ancestry. Um, that brings me to your thoughts on what are some of the factors that influence economic performance of ethnic/racial groups.
So this is a little bit of a sociological, anthropological question, but I think the one thing that everyone should agree on, although not everyone does, is it's obvious that culture plays at least some role. Different groups have different cultures. And I think when people, the objection to pointing out culture is that people say, well, you're saying that one group has a superior culture. Well, sometimes there are some factors that, being, hardworking or interested in education seem like good things. But I wouldn't say the example. I just wrote a paper about this. I'll give you an example. In the United States, we have about 7 million Jews in the United States. About 15% of them now are Orthodox Jews, people who adhere to traditional religious law. But among those Orthodox Jews, they're divided into, well, a lot of groups, but the two major groups we could say are people who dress in a normal Western style world and send their kids to regular universities. And even though they adhere to Jewish law, they're much more integrated to American life. And then there are the other group who are often in English known as ultra Orthodox or Haredim, and they're the ones who wear the black outfits and the black hats, and they tend to privilege studying Torah, and they tend to be much more insular. Now, if you look at these two groups, they're genetically basically the same. both Ashkenazi, almost overwhelmingly Ashkenazi Jews who are very, so you can't look at that. They have they have similar religious customs, adhere to Jewish law, but what we call the modern Orthodox, the ones who are more integrated, they're they have very high family incomes. They tend to limit themselves to 3 or 4 kids, sometimes only have 2 or 1 kid, and they're very prosperous economically. If you look at the ultra Orthodox, a substantial percentage of them live in poverty. They they have an average of like 6 children. Sometimes they have 10 or 12 or 14. They don't go to major universities. They don't go to university at all. Sometimes they don't even speak English fluently because their language is in Yiddish. And so so first of all, what's the difference between these two groups? It's just the culture that they live in. One group prizes being assimilated into society and prizes higher education and economic prosperity. And the other group privileges keeping the community more insular and studying Jewish texts, for the men at least, a lot more. Now, would you say that one group is inferior or superior? I would say from like a social point of view, the rest of us would rather other groups be more prosperous because that leads to more gains from trade for us, less, government transfer payments. But as far as like morally speaking, who am I to say, which group has a better culture? The more insular groups also tend to be more charitable, and they tend to have very low rates of social pathologies like drug use, alcoholism, and their very low rates of divorce. So I think we should go away from thinking, so along those lines, some groups really may really focus on, we want everyone in our group to be economically successful and study as much as possible. And when they're 5 years old, we stop putting them in after school programs and educating them. And someone else said, I want my kids to be more well-rounded. We should value leisure more. We should value family time more. If in some cultures, if you grow up in New York and you're offered a great job in Los Angeles, you just pack up and go to Los Angeles. Other cultures would be, oh, you can't leave your family and go off to Los Angeles. How will your parents see their grandchildren, right? And again, I don't think that's necessarily inferior or superior. It's just different modes, and obviously one's going to lead to more economic success than the other, but that's obviously some sort of factor. So so we could say, again, putting aside other factors, we could say culture matters. I should say also that like especially this guy Ibram Kendi, who's sort of a well-known racial rabble rouser on the far left. I mean, he'll say, well, if you say someone's culture is part of the problem, you're ignoring the history of oppression potentially, and you're also, again, saying they're inferior. So I already dealt with the inferiority thing. But as far as the history of oppression, again, I'm not an anthropologist, I'm not a sociologist, but let's just imagine there's let's say you're in Peru, to get out of the United States. I lived in Peru. Let's say the indigenous people of Peru were historically kept down. They couldn't get managerial jobs. They weren't allowed to become professors, get into higher education. They were excluded from higher education. Their schools were terrible. They may have seen a lot less gain from investing in education in law and other long-term projects than if you had more opportunity. If you over a course of a long period of time see that there's less gain from a particular activity like higher education, you're less likely to make that part of your culture because why bother? And that might become counterproductive when the situation around you changes and there are higher gains, but culture doesn't immediately follow opportunity. So again, without, I don't want to say anything because I'm not not an anthropologist, not a sociologist, and I don't want to not even cast aspersions, but even talk about groups that I'm not intimately familiar with the way I might be familiar with Orthodox Jews. But one thing we can, I think, say is culture matters, urbanization matters, right? The longer your group's been urbanized, the more likely they are to have the kind of skills and so forth that a modern economy desires. Religion can matter. Like some religions are more achievement oriented and some are more spiritually oriented, and all sorts of factors along those lines.
Of course, that returns to Max Weber's case for the Protestant ethic.
Yeah, I mean, I don't know what the status of Weber's theory is nowadays in the academia, but surely it matters. One thing I remember reading about years ago which was very interesting, was that in some African societies, that there was a real disincentive to becoming economically successful in that any that you had a clan that you were part of, essentially your siblings, your cousins, and so forth. And going back from the days of hunting and gathering, when whoever was successful in the hunt would, of course, share, right? Because a lot of the hunting is basically random. You happen to see an antelope that day. So the culture developed that if you succeed in the hunt, you share with everybody. So when they very quickly transitioned from hunter gatherer to a more modern society, the tradition though stayed the same. So that if you got a good job somewhere, you're expected not to keep the gains to yourself or your immediate family, but to share with all your relatives. Well, if you have to give 90% of, let's say what you earn to your relatives, you only get to keep 10% yourself. That's like having a 90% tax on your earnings, and makes it much less desirable to invest in working hard and getting an education and so forth if you're not going to get to keep those gains. I guess you get some feeling of satisfaction of helping your relatives, but most of us are mostly motivated by helping ourselves and our immediate family, and everyone else is kind of secondary.
Mhm. Right. So moving on to libertarianism. So your essay discusses quite a bit about the interplay between the libertarian political thought and um, their views on the civil rights anti-discrimination legal framework from 64 onwards. Um, the way I see it, there are at least two currents of libertarianism. One can be reasonably interpreted as pro-civil rights, and the other being anti-civil rights. So I guess from the pro-civil rights point of view, the Jim Crow laws are state imposed, and they are a state imposition on the private sphere, and they want to guard the private sphere against any intervention from the government. Um, I believe I think it was either Thomas Sowell or Walter Williams who said that one of the very powerful incentives to abolish the separate but equal doctrine is that, well, it just costs too much to produce train cars that accommodate, well, blacks and whites separately. Um, but of course, there's also another current of libertarianism that says that, well, the Civil Rights Act of 64, as well as the other laws that you that were born out that act, represents an imposition of the federal government into the state government, and therefore, it the tyranny of big government and such. So I wonder whether you've observed this dynamic between like American libertarianism as of late, and to what extent is one side gaining advantage over the other?
Sure, and I mean, I think that this book chapter you mentioned that sparked our meeting today was originally published by the Cato Institute in a little bit shorter version, and there were responses from other libertarians. So my position was that's okay to have anti-discrimination laws, but that we should put a hard stop when they start infringing on constitutional rights. And other responded said, no, the only way you should have of course, the government shouldn't discriminate, but once you get rid of that, the only way of combating discrimination is through voluntary action, boycotts, publicity, and so forth. But so I've been thinking about this a lot lately. I even went to a sort of little seminar on this. I think there's a bigger distinction or a greater issue here of in libertarianism of those who it's not even being more dogmatic. It's that they only want to talk about long-term libertarian solutions, and they don't want to talk about second best. And there are other libertarians who say, whatever the long term is, we have to live in society right now and figure out what to do in the meantime. And even if that might undermine some libertarian solution, we can't just roll it. So let me give you an example that's outside civil rights laws entirely. We have a huge debate now in the United States about public education on a whole variety of levels. One major issue is to what extent is our woke ideas in being uh, put into the curriculum, and to what extent, especially in local, more radical school districts and college towns and places like San Francisco, and to what extent should we have state or local regulation to prohibit woke indoctrination, as people call it. Another issue is with transgenderism. Should schools be allowed to start referring to your son as your daughter without telling you, give them a new name? Should girls be allowed, biological girls be allowed to use boys' locker room if they identify as boys and vice versa? And those are some serious issues. And a lot of libertarians, if you ask them, will say, well, the answer is not to have public schools. We should have school vouchers. We should get like, okay, that's nice. And you could point out that it's fine to point out that these controversies would go away from the public sphere if all the schools were private and each parent could sort of decide what schools they want to send the kids to. Of course, there'll still be arguments on whether we should legislate curriculum or legislate about transgenderism, but we wouldn't be directly regulating. And and you could also say, look, I don't want to get distracted by these current issues. I want to just focus on my long-term goal of having school vouchers or even completely private education. But other libertarians say, look, that's all very nice, but and I'm in favor of vouchers or whatever or what have you. But right now, there's a bill in my state Senate to, ban critical race theory from the curriculum, or to require schools to allow people to use the locker rooms and showers of the sex they identify with. I want to know what to vote about, how to vote now, right? So I think so if we get back to civil rights legislation, I think this is the same thing that we're arguing about in 1964. You could argue, well, look, in the long term, what I want is a libertarian society, so I don't want the federal government to start intervening. Federal government starting to intervene will cause all sorts of problems, which in fact it has, with start encroaching on civil liberties, and whatever the dangers of allowing Jim Crow to continue, we just don't want the government to get involved. Let's work towards a private solution. On the other hand, this is especially important in the context of civil rights laws. You can say, well, look, this wasn't really a situation where libertarianism had set up. We had a free market in the Jim Crow South determining who goes to what school and who gets employed. Again, we had this cartel of private violence, public violence, and social pressure and law. And someone needs to come and break up the cartel. Now, it's true the cartel could be undermined by taking just one of those legs away, taking away the law part. But even that's kind of tricky. Because let's say you just say, okay, from now on, the government's not allowed to discriminate in the South, the state government. Well, how do you ensure they're not going to discriminate? How do you know that the restaurant owner who integrates is not going to get a visit from the sheriff and says, people here are really upset about the fact that you're allowing Black people to sit in your restaurant. And, I know you have a zoning permit hearing coming up next month to try to expand your restaurant. It'd be a real shame if the city council voted that down, right? That sort of thing. How do you stop that? Over time, maybe you could stop it with persuasion and all that, but it is sort of an unlibertarian situation. So my ultimate position on this was twofold. First, because this kind of cartel exists, there was really no way of stopping state governments from implicitly discriminating. The only other libertarian alternative truly would be to have the federal government come and take over everything. And there was no capacity or will to do that in 1964. It wasn't a real option. And to say we're just going to wait for moral suasion to change things is allowing a sort of unlibertarian oppression to continue. So we have two unlibertarian choices: the unlibertarian system continue and oppress Black people, or we could have federal intervention to break the cartel, which will lead to its own problems and in some ways unlibertarian itself. And I was okay with that. The second thing I said is, look, and then, one thing that's really interesting about that's really underappreciated is that when the segregation laws were repealed by, local segregation was banned by federal statute. At the time, people predicted it would take 20 or 30 years for the South to integrate because there was so much opposition to integration in restaurants and parks and all that. And in fact, it happened almost immediately. I mean, there were a few holdouts. By 1970, let's say, there was almost no segregation left. And that just goes to show how much just getting rid of the cartel could work. Now, what about today? You can say, well, look, today, Bernstein, we've got rid of the cartel. We even have affirmative action, and now the government has expanded its anti-discrimination edifice into all sorts of other things where there was no cartels and where it's completely counterproductive and where it's infringing on civil liberties. What do we do? So first thing I say is, well, first thing is make sure that when the Constitution is at issue, that the laws don't overcome them. Protect the First Amendment, protect other civil liberties. The second thing is that we have to be careful when we say, oh, but we want to get rid of the civil rights laws because they're unlibertarian, because obviously we don't live in a libertarian society at all. Everything is regulated very heavily by the government. So when you meet a libertarian, some of the kind of people you talked about, but not all of them, who says, I'm really, really upset about anti-discrimination laws, and that's the one thing I really care about most. You kind of like, well, why would that be the one thing that bothers you so much? Why, so government is doing so many terrible things to so many people, and here's something that, yes, it has some bad effects, but it's not, doesn't seem like it's the worst thing government's doing. Why is, I mean, no, and in some cases, someone may be really upset because of a very specific issue. Okay. But in general, what I say in the chapter you wrote is that if I were a libertarian, if I were suddenly, dictator of the United States, and I said, okay, I need to start repealing federal law, where on the list would anti-discrimination laws be? I put them pretty far down the list. And I put them pretty far down the list because A, again, the government does also other bad things. And also B, I wouldn't want people to think that I'm focusing on these laws because really ultimately I'm against giving, people having civil rights. Once we repeal like 80% of the other laws, we can say, okay, you can see we're generally libertarian. This is just consistent. But if you're really focused, first thing I want to do is repeal anti-discrimination laws. That leads to an inference, which is often going to be correct, that you're not solely motivated by libertarian considerations, but that you actually really have some issue with minority groups.
Okay. So, um, so to end this conversation, which I find incredibly interesting, I'd like to hear your thoughts on two Supreme Court cases that have are related somewhat to, well, both the Civil Rights Act of '64 and the subsequent Voting Rights Act of '65. Let's start with the earlier one, Shelby County versus Holder. Now that one is I think perhaps conservatives and libertarians and I guess constitutionalists may be happy with it, but I hear that many liberals are not very happy with it. Now, the way I can summarize it is that it removes this requirement for state and local governments uh, to obtain clearance from the federal government in regards to how their voting processes turn out, whether the voting process were legitimate or not. And of course, it was based on the Voting Rights Act of '65's outlawing of, say, southern state and local governments that were discriminating against blacks. Um, the rationale I believe that the court gave at that time is that, well, 2013 is no longer 1965, and that kind of discrimination it's no longer socially acceptable. So I'd like to hear your thoughts on that.
Sure. So, under our federal system, voting rules would normally, once they meet basic constitutional requirements, would normally be subject to state and local regulation, not federal regulation. Federal government said in 1965, under the 15th Amendment, which guarantees the right to vote, we have the power to make sure black people have been excluded from voting. We're going to, and it's been, and throughout the South. So all this huge region of the South from now on, if they ever do anything to change their voting system, they have to get what you mentioned pre-clearance from the Justice Department, and that's based, on the current situation where Black people aren't being allowed to vote in these places. And at some point, some of the counties sued and said, look, like you mentioned, this isn't 1965. It's 40, plus years later, and there's no valid constitutional reason to single our counties out and not make, there are counties in the north or the west that have large Black or Hispanic populations that may actually be more likely to be discriminating in their voting system than we are. Why are we required to engage in pre-clearance and they're not? And the fact is, Congress have been trying to pass a new update to the Voting Rights Act for years, but because our Congress is kind of deadlocked on everything, they can't really do anything. So the Supreme Court said, look, we agree with the plaintiffs that you can't rely indefinitely on factual findings from a certain period of time to justify what would otherwise be extraordinary uses of federal power. And I think that is right in theory. The only real pragmatic question is that given that Congress is basically largely fails to legislate nowadays and leaves everything up to the other branches of government, can we actually expect Congress to go and they haven't gone back, right? Now it's been 11 years in Shelby County. Congress could have gone back and said, okay, let's figure out which areas of the country really need pre-clearance still, where there's some real evidence that discrimination is still going on, or at least is a strong possibility, and they haven't. So in that sense, that prediction that it meant that we're not going to have pre-clearance anymore was right. But just as a technical legal matter, I mean, if the justification for the law is here are the circumstances in 1965, this is why the federal government has to put these extraordinary powers into place. I think at some point there has to be a revisiting of those facts, if not by Congress, at least by the Justice Department, and do a real investigation to say, is this exercise of federal power still justified?
Okay, so
And
finally,
by the way, I mean, I
yeah.
don't think, I'm not saying there's no voting shenanigans going on today, but it's nothing like what was in 1960. Things have changed dramatically. And really, for whatever it's worth, today is a very hard issue, which I'm not sure how I deal with if I were on the court, which is that because at least, I mean, it looks like it might be changing a little bit, but at least until recently, typically 90% of Black Americans would vote for the Democrats. If you structure the districts in such a way as to concentrate the Democrats into certain districts to make it more likely Republicans will win elsewhere. Are you discriminating against Black people, or are you just discriminating against Democrats? And how do you tell the difference? And that is an extremely difficult question because it's so intertwined.
No, finally, the other case, the one that actually conservatives were angry about, but liberals were happy about, and this one relates to the 64 Civil Rights Act, Bostock versus Clayton County. This is the one that states that it is against the law, is against the Constitution to discriminate against individuals who are of a different sexual orientation than straight and of a different gender identity than either the one that they were born with or the previously known categories of male and female. Now, of course, as someone who advocates for this kind of anti-discrimination, I find that it is reasonably sound decision. But what I have a problem with is that the court stretches the Title VII of the act on the discrimination on the basis of sex. They stretch it to mean both sexual orientation and gender identity. The latter of which I find controversially enough to be kind of a fiction, and I think the court unwittingly have legitimized this fiction. So I'd like to hear your thoughts on it too.
Sure. So, I mean, the four liberals who are the court at the time voted in favor, as did Justice Gorsuch. So, four liberals are just doing it because they like the policy, frankly. The more interesting issue is Justice Gorsuch. He said, well, look, it says on the basis of sex. I'm going to read that naively, not look at what on the basis of sex meant in 1964, but just look at how people, not look at how people have interpreted, but just look at what the word on the basis of sex means. So he says, well, if you are if you are someone who has sexual feelings towards men and you're a woman, you're not going to get discriminated against. But if you're a man and you have those same feelings and you're being discriminated against because you're homosexual, that is therefore based on sex. Now, I don't think that was persuasive in this context solely because this wasn't really like an ambiguity in the law. It's more like in 1964, no one would have said that, like almost no one. So it's one thing if it's ambiguous at the time, then just like read it naively, but there really is no ambiguity. I also have my own personal philosophy about how ambiguous even laws that are ambiguous should be interpreted, or laws where a word can have several different meanings. And my view is that if Congress is trying to exercise, or the state legislature for that matter, exercise power over private parties, it should have to do so reasonably explicitly, so that a reasonable person who reads the law can know what's allowed and what's not allowed. And then when Congress votes in the law, the public could say, well, we don't want that because we know it's going to have this effect. So if we apply, and by the way, no one in the Supreme Court adopts this very narrow reading of legislation. So this is my own, maybe I'll write an article about it someday. This is my own little idiosyncratic view. But if you took that view, obviously, if they wanted to prohibit discrimination based on sexual identity or gender identity, they should have said that explicitly, because you can't read because of sex and know that's what they meant. And again, if there's any I don't think it's really ambiguous again at the time, but even if you say there's ambiguity, and therefore we'll use a naive reading like Gorsuch, I say, well, there's ambiguity. Congress didn't let people know it was doing this. Because they didn't let people know it was doing this, no one could object. If no one could, so the Congress should not be able to project its power in that way.
Yes, of course. And I certainly hope that this conversation may be a springboard for a sort of sequel that you can write to Classified. And this time, instead of race, you deal with the concept of sex and how it's been expanded to, well, sexual orientation and gender identity. Well, if you do write that book, I look forward to reading it and perhaps to talk to you on this show.
Okay, great. Thanks for having me.
All right. Have a good day, David.
Bye.